I now recognize the distinguished ranking member, Mr. Johnson, from the Go Tigers state, for his opening statement.
Thank you, Mr. Chairman. I appreciate you and all of our colleagues and look forward to working with you all on the subcommittee this year. And thank you to our witnesses for being here with us. Today's hearing on the National Emergencies Act of 1976 takes place at a time in history in which Congress has increasingly abdicated its legislative powers over many decades. It's like having a hearing on puddles right now in the middle of a hurricane. That's my Louisiana reference for you. I'd like to use my time today to take a step back and explore how the polarization of Congress seems to have drawn both parties at times further away from our constitutional core, and namely, that is what's been referenced, Article 1 of the Constitution. As the former historian of the House of Representatives, Robert Rimini, has written, quote, "The framers of the Constitution were absolutely committed to the belief that a representative body accountable to its constituents was the surest means of protecting liberty and individual rights. So anxious were they to affirm legislative supremacy in the new government that they failed to flesh out the executive and judicial departments in the Constitution, leaving that task to Congress and thereby assuring that the legislative and the legislature would remain control of the structure and authority of both of those branches," unquote. But today, the separation of powers, so carefully designed by the framers of our Constitution, has been greatly obscured. Let's take a look at more recent history. Just consider the last 5 years. The first section of the first article of the Constitution provides that, quote, "all legislative powers herein granted shall be vested in a Congress of the United States," unquote. And in the Obamacare statute, Congress provided for clear statutory guidelines for compliance, including this one regarding the mandates the statute imposes on employers. Quote, "The amendments made by this section shall apply to months beginning after December 31, 2013. Yet the Obama administration unilaterally sought to rewrite the law, not by working with the people's duly elected representatives, but through things like blog posts, where they removed penalties for employers who would otherwise be required to provide insurance coverage for their employees. They did it through regulatory fact sheets, which created an entirely new category of businesses and exempted them from their responsibility under the law. They used things like letters, which specifically explained that people would have to have their health insurance terminated under Obamacare, of course in violation of President Obama's famous promise that if you like your health care plan, you can keep it. And then they claimed to suspend the law's insurance requirements to a date uncertain. This one letter alone, referenced there, suspended the application of 8 key provisions of the Obamacare law. And why was this done? To delay the terrible consequences of Obamacare until after the next election cycle. The Obama administration also admitted to using federal taxpayer money to pay subsidies to insurance companies under Section 1402 of the Affordable Care Act, even though appropriations for such payments were never made by Congress, in violation of Article 1, Section 9, Clause 7 of the Constitution, which expressly states, quote, "No money shall be drawn from the Treasury, but in consequence of appropriations made by law," unquote. When it submitted its fiscal year 2014 budget to Congress, the Obama administration correctly recognized it could not make Section 1402 offset program payments to insurers unless and until Congress specifically appropriated funds for that purpose. In July 2013, the Senate Appropriations Committee declined to approve the administration's request. In fact, neither the House nor the Senate ever adopted a bill approving the administration's request, and no bill containing an appropriation to fund that section was presented to the President for his signature or veto. Congress also didn't appropriate funds for Section 1402 for fiscal year 2015, and yet the administration went ahead and funded the insurance subsidy program anyway. Notwithstanding the lack of any appropriation for that section, either in Obamacare in that law or in any fiscal year 2014 appropriations bill, the Obama administration unilaterally began making such payments to insurers in January 2014 and continued making them thereafter. One of the witnesses here today, Professor Jonathan Turley, challenged the rank unconstitutionality of those unilateral executive actions on behalf of the House of Representatives, and it led to a federal district court ruling that said, quote, "Neither the President nor his officers can authorize appropriations. The assent of the House of Representatives is required before any public monies are spent. Congress's power of the purse is the ultimate check on the otherwise unbounded power of the executive. The genius of our framers was to limit the executive's power by a valid reservation of congressional control over funds in the Treasury. Disregard for that reservation works a grievous harm on the House, which is deprived of its rightful and necessary place under the Constitution." Judge Collier ultimately ruled in favor of the House on May 12, 2016, and found that the Obama administration violated the Constitution and committing billions of dollars from the U.S. Treasury without the approval of Congress. The Trump administration subsequently ended that unconstitutional funding program. Then November 2014, President Obama unilaterally and unconstitutionally created a program that would suspend immigration laws for millions of people who are in this country illegally without authorization by Congress. The President urged Congress to enact a statute to create such a program under law, but Congress did not, even when his party controlled both houses of Congress. And despite claiming the situation was urgent, he didn't act unilaterally until November 2014. Whether or not the President delayed action until November 2014 for political reasons, he knew the actions he ultimately did take were unconstitutional. And we know that from his many public statements in which he himself directly addressed the issue of the lack of legal and constitutional authority to do what he ultimately did, that he recognized it as well. He said in his own words at one point, he changed the law. Now, all that happened without any protest from the other side of the aisle, even though both sides of the aisle work together here under the same Capitol dome, and we share the same legislative powers under Article 1. But today, here we are having a hearing on President Trump's exercise of clearly delegated authority under a statute that was duly enacted by Congress. We can debate the policy merits of the authorizing statute, but there's no doubt the National Emergencies Act of 1976 and related federal statutes constitute a clear delegation by Congress of parts of its appropriation powers to the President, subject to the President's declaration of a national emergency, which is a term that is left to the President alone to define. There is a crisis at the border, and everyone at some point or another has acknowledged that, and the President has the authority to address that crisis under a federal statute that's duly enacted by Congress. I would just say this in closing: it's time to drop the politics and pick up our principles. We in Congress must rediscover the principled basis for our Article 1 powers. Until we do that, we will move in partisan fits and starts, one day in this direction, next day in that direction, and we'll discover one day that we're not moving forward, but rather in circles, down a whirlpool that erodes our legislative powers, spinning with increasing speed in smaller and smaller circles. I hope this hearing can help right our ship and help provide us a principled anchor as Congress moves ahead. I look forward to hearing from all of our witnesses here today. I yield back.